welcome to Macro Pro and Friends webinar series. I'm Diane Cohen, and I would like to do a little bit of housekeeping before we get started with our webinar this morning. So today's presentation is worth 1 CEU. You must be logged on to the GoToWebinar platform in order to receive that certificate. So if you're calling in, please make sure that you dial in on your computer. Secondly, if you have any questions for our speakers, you may do so through the question portion of our control panel. And we will ask those questions if there's time at the end of the presentation. There are handouts for today's event, so please make sure that you download them. I'm really excited about today's presentation. It is something that has created a lot of buzz and a lot of interest. Today, I am joined by Scott Yarnell, the Director of Client Services for Gale, Sutow Associates. How are you doing, Scott?
I'm doing well, Diane. How are you today?
I'm great. I'm looking forward to the holidays. How about you?
Same. Looking forward to that deep fried turkey.
That sounds delicious. So today we have a lot of interest, as I mentioned. We have over 250 people. Can you tell us a little bit about what is going to be covered in today's presentation?
Yeah, absolutely. Thank you for having us today. So this presentation is just going to be a pared down version of a larger presentation that we've put together in the past. So the goal of today's presentation is going to be essentially just how to mitigate excessive med legal costs, some tips and tricks on when to use an AME versus QME, finding some red flags in reports, and also the impacts that we've seen so far in the new med legal fee schedule, and also what to look out for.
Well, there's going to be a lot of questions, I'm certain. So I just want to remind everybody again, use that question box. And if we're not unable to answer your questions today, we will make sure that the attorney speaking will get a copy of that and get your email address so they can reply back to you. So Scott, perhaps you could tell us a little bit about your firm and the speakers today.
Absolutely. So my name is Scott Yarnell, and I'm the Director of Client Services for Gale, Sutow Associates. We're a workers' compensation defense firm with 5 offices located throughout California, and we offer statewide coverage. We represent clients such as public entities, school districts, staffing agencies, retail and food service and restaurants in all aspects of workers' compensation defense, including 132A, serious and willful and subrogation matters. So today's topic is going to be the med legal strategies, and it's presented by 2 of our partners in our firm who I'd like to introduce. Andrew Trutanich, who's a partner in our Orange County office, and Leigh Finch, who is a partner in our Orange County and Inland Empire offices. Thank you both for being here today, Andrew and Leigh. We appreciate it. At this point, I will go ahead and turn the presentation over to Andrew to get started.
All right, thank you, Scott, and good morning, everybody. I hope everybody's doing well. I am Andrew Trutanich, as Scott said, and I'm very happy to be here to present this topic on med legal strategies. So when we're talking about medical legal evaluations, everybody knows mainly that we're talking about AMEs and QMEs, when to use one over the other, you know, what strategies we employ when we start thinking about going through the discovery process, and how those decisions that we make through the medical legal process can, you know, help us in the litigation of our case. One of the things that we do in almost every case is go through a medical legal evaluation. If we're not able to settle the case early, you know, chances are at some point in time we're going to either have to have an AME or a QME. So we have to decide at the outset, you know, would it be beneficial for us to utilize an AME in a case over a QME, and what are some of the reasons that we utilize an AME? You know, we like to be able to somewhat have a better idea as to what we're getting into with a medical legal evaluation. Usually these are doctors that we know, we've used in the past, we know what their reporting is like, and we like to try to eliminate as much of the unknown as possible. An AME functions essentially the same as a QME. They're going to be addressing the same issues as the QME in their report. And when you look at the two reports, really, aside from them telling you it's an agreed medical evaluation over a qualified medical evaluation, you're not going to see any difference between the two. They're still going to be addressing all the contested medical issues within the scope of their practice. They advise you if any issues are outside the scope. They have to be in compliance with the California Code of Regulations, in that their reports have to have the history of the injury, the complaints of the applicant, their review of records, what they're relying on as far as coming to their conclusions. One thing also to note, and you'll see this a little bit later when we talk about the changes in the fee schedule, it is more expensive than a QME, and with the changes this year, it's going to be about 35% more expensive to use an AME over a QME. So we can only agree to an AME if the applicant is represented. So we cannot agree to an AME if the applicant is in pro per. However, there's no requirement that a defendant be represented. So a lot of times, you know, claims adjusters will be handling a case before it gets referred out and for representation. They can't agree with an applicant's attorney to utilize an AME in a case. However, you should always do it in writing. You can agree orally. However, if there's some sort of issue that comes up later on down the line that needs to be litigated, the court really does not favor oral agreements. They're going to really want to see that there was an agreement in writing. The AME can only be canceled by written mutual consent. There has been a case that has found that an applicant was allowed to withdraw from an AME agreement, but it was before they had been evaluated. There is some question, I think, out there as to whether, you know, say an applicant is represented by one attorney who agrees to an AME, has not yet been evaluated, and then subs out that attorney, a new attorney comes in, and whether they can withdraw from the AME agreement. So that's a question that's still kind of up in the air. So when we're going to a medical legal evaluation with either a QME or AME, there are some distinctions between the two as to what information in the initial communication that needs to be provided. When you're dealing with a QME, all the information that is sent to the QME needs to be served on the other side 20 days prior to it being sent to the evaluator. So the subsequent communications can just be at the same time, but the initial communication needs to be served on the other side 20 days prior. So typically what happens is we get an evaluation date set, we put together a schedule of records, collect everything that we, as far as all the medical records and any other relevant items that we're going to send to the QME, we put those together in a schedule. We do a proposed advocacy letter or a proposed joint letter. We send that to the other side 20 days prior to the evaluation, and they can either agree, do their own letter, do their own schedule of records, which Leigh's going to be talking about a little bit later. If the opposing party objects to some sort of non-medical information being sent within 10 days, then it can't be sent over to the other side unless it's ordered by a judge. So when we're dealing with an AME, the communications need to be in writing and just served on the opposing side at the same time that it's sent to the QME. So there's not that 20-day requirement. However, the Labor Code does require that there be an agreement between the parties before information is provided to the AME. So there are penalties for failure to comply with those rules, because when you violate one of those rules, we're talking about ex parte communication. And so when there has been an ex parte communication, the trier of fact is going to determine what the actual remedy is for that. And they have a wide variety. The judge is going to have a wide variety to determine what the remedy is going to be. It could be a new panel. It could be they just don't admit the report that's in question. They can sanction the other side. They're going to look at a lot of the different factors and decide what the appropriate remedy is going to be. The Labor Code does indicate, though, that communications that have to do with appointments, records going over to the other side, evaluation dates, those are not considered ex parte communications. So if you're just have someone from the law firm staff contacting somebody from the staff of the QME or AME office regarding some records being sent or the evaluation date, that is not going to be considered ex parte communication. There's not going to be able to be an objection by the other side based on that communication. So what types of information can be sent to an AME or a QME ahead of the evaluation? Well, obviously, all of the treatment records are going to be sent. Any other medical records that are relevant to determination of medical disputes, so prior treatment records, you know, advocacy letter outlining the issues, and any non-medical records that are relevant. So typically what we're going to be seeing in the schedule of records that's sent over to an AME or QME are going to be SCT records for prior treatment, which may be relevant. You know, we usually do depositions in cases where we determine if there are any other, you know, records from prior injuries, prior workers' compensation injuries, prior motor vehicle accidents, prior, you know, civil slip and fall type cases, things like that. Anything which may be relevant in this case, we're going to try and get those records. We're going to send them to the QME if they're relevant. Also, certain documents maybe from a personnel file which may be relevant. Sometimes there's incident reports. Sometimes, you know, we have videos of incidents that occur, you know, on surveillance, sub rosa video, which may be relevant. You know, that's like the type of non-medical things. So what may not be sent to an AME or QME is a medical legal report that has been rejected by a party, which is untimely. So let's imagine a situation where we have a QME who evaluates the applicant. He does not issue a timely report, and one party objects to that timely report and gets a new panel. Then at a later time, say that report comes in and it's a favorable report, you can't then send that favorable report to the new doctor. That report is going to be out because it's already been found to be untimely and you've gotten a new panel. Also, any evaluation or consulting report written by a doctor other than a treating physician or secondary treating physician in the case, unless it's first ruled on by a workers' compensation judge. Obviously, any report that's already been stricken cannot go. And a party can waive compliance with CCR 35. Imagine a situation where a party sends something to an AME or QME that's objectionable, and then they can't come around at a later time and object to the AME or QME reviewing that document that they weren't allowed to review, and say that they get a remedy for it. If the aggrieved party is the one that sent the documents over to the doctor, they are not then entitled to a remedy. If you provide information to an AME or QME for the first time at a deposition, the court says that you're not allowed to circumvent Labor Code Section 4062.3 by then providing the document at the deposition. So this case Trapero that we have listed here has to do with vocational reports. The case Juan versus Community Health Network has to do with sub rosa video. In each of those cases, the attorney tried to produce for the first time those documents to the medical legal evaluator without first having served it on the other side. And the court says that you're not allowed to do that. You have to first serve it on the other side if you're going to present it to a medical legal evaluator. And again, the courts are also going to have a wide variety of remedies to determine if there is an issue that needs to be resolved in that regard. So what about timeliness of the reports? We just mentioned a couple moments ago that you know, sometimes there'll be a late report. So for an AME or QME, the initial report has to be submitted 30 days from the date of the exam. If the report is not timely, then either party can object and request a new evaluator. So normally this is going to be coming up when there's a QME not with an AME. Think about the reason of why we want an AME in the first place. So this is somebody that we agreed upon. This is not somebody that we're looking to have their report kicked, especially for something, you know, being late on their initial report. One of the reasons we agree to an AME in the outset is we want to avoid the gamble of a QME panel and what we're going to get in that QME panel. And so if we objected to the timeliness of the report, what's the remedy going to be? It's going to be a QME panel. So we can't get a remedy that has them agree to a new AME. It's going to be a replacement by a QME. So normally we're not going to be doing that with an AME. If there is a supplemental report that's late, they have the QME or AME will have 60 days from the day of the written request to issue the supplemental report. If that supplemental report is late, and we're going to talk about it in another slide, it's a little less clear as to what the remedy is going to be. So when we have the right to object, we have to decide if we are going to object, because as we mentioned, the remedy is going to be a new panel. We have to determine if we have a bad panel already, are we trying to get out of that for some reason? Let's say we got a QME panel that was pretty good, and let's say we've had this doctor before and the doctor's not bad, but has not issued a report timely. Well, if we look at the possibility of maybe getting a bad panel thereafter, the replacement panel being worse, maybe we don't want to issue that objection, even though we have the right to issue that objection. Maybe we're gonna, exhaust some other options like we would do in an AME. When we get an AME report that is not issued within 30 days, maybe we contact the doctor's office and try to get status and find out what the issue is. Just because we have the right to object does not necessarily mean that we should object or that it may benefit us after, because once we object, that's it. So the objections are to an AME or QME are going to be obviously for violations of 4062.3, and that was what we talked about previously, things being served on the other side prior to the evaluation, and obviously timeliness. So if we're going to make that objection, the objection must be made prior to the report coming in. Otherwise, it's not going to be valid. The court knows that if we have the benefit of seeing the report before we object to it, then we can make the determination based on the findings of that report if we want to object, if it's untimely or some other reason. We essentially are getting another crack at the medical legal process, and maybe we would get a better result the second time around. The court says that is doctor shopping and that is not allowed. So if we are going to make this objection, we have to make sure that we get it in before the report is actually issued. So the remedy for we already talked about the remedy for the initial report. What's the remedy for the late supplemental report? Well, the case law is inconsistent on that. This Corrado case that I have listed here deals with that issue, and it indicates again that the judge has a wide discretion to order a replacement panel based on good cause. They're going to look at the length of the delay, the prejudice, what efforts have been made to remedy the situation in getting that timely supplemental report, and case-specific justifications to keep the QME. So really, the courts don't really want to completely undo the process in the middle of it, so they're going to be looking at these factors as a way to essentially find a remedy other than what's going to be a complete replacement if it's just a supplemental report that's late. So we have our AME or QME, and we have to now determine what evidence those reports could have at trial. So generally, it's the duty of the court to weigh the medical evidence in making its decision. And what they're trying to do is find out what is going to be substantial medical evidence going forward. Usually, a board is going to give greater weight to an AME report over a QME report. This case, Power versus WCAB, says in the case that it is presumed that the AME has been chosen by the parties because of the expertise and their neutrality. Therefore, the opinion should be followed unless there's good reason to find that the opinion is unpersuasive. So this is one of the reasons why we agree to AMEs, is because in order to properly evaluate the case, it's helpful when we have that certainty in knowing that this AME opinion is going to be the one that the court follows. So the court's going to be looking at several factors and determining if something is substantial medical evidence, if it's known to be erroneous, based on facts that are no longer germane, inadequate medical history, incorrect legal theory, based on speculation, or it just doesn't have good reasoning. It's important to remember that when we're dealing with a QME rather than an AME, there is no presumption given to a QME. So if there is a primary treating physician permanent and stationary report that comments on all of these issues, there's not going to be any presumption given to a QME over that primary treating physician report in determining whether or not one is substantial over the other. That presumption is given to an AME, which is another reason that benefits us. So this case, Braywood, is lays out the standard of what is substantial medical evidence and what the definition is. And when we're determining what strategy we're going to employ in the case, and we have our medical legal evaluations, we have to evaluate that in light of what the court needs to find in order to be substantial medical evidence. Do we have a well-reasoned report? Is it a washout report? I recently received a QME report that found no industrial injury, which is great. The result was good. However, the entire report was only 9 pages long. And I think the section on causation, which is the most important section in that doctor finding that something was not substantial medical evidence, or finding that there was no causation, was only 1 sentence long. So we have to determine, is that going to be substantial medical evidence? We have to look at what are we going up against? Do we want to put that report up against maybe a well-reasoned primary treating physician report going forward to trial? Do we want to see if maybe in light of the evidence, do we want to try to reach a settlement agreement, somewhere in between? Or there's also been times where, there isn't a great QME report, not well-reasoned. There isn't a great PTP report, not well-reasoned. And a judge has pushed both parties to use an AME and get rid of both of those, just so you have that certainty and you have something that they can rely on that will actually be considered substantial medical evidence. Dealing with additional panels, so claims involving multiple body parts and body systems. So example is, it's no surprise to anybody handling claims that it's almost commonplace today in workers' compensation that as a matter of course, the applicant's attorneys will file applications with multiple body systems listed on their orthopedic, neurology, internal, and we'll sync multiple panels in all of those different specialties, as a way to boost up the permanent disability value of a case. So if there is a need for an additional panel, if a medical dispute arises outside of the expertise of the initial evaluator. So let's say first we have a QME or an AME in orthopedic, and there is some internal issue. If there is a dispute outside of their specialty, they can get a different panel, an additional specialty, if by written oral agreement or by order of the court. And the court's going to determine what good cause is for getting that additional panel. So generally, if the medical legal evaluator has said that there's a need for an additional panel in a different specialty, the court's going to find that is a good cause. I've listed 2 cases here. One, this Hernandez case. Just because a body part is alleged in an application, it does not automatically mean that there is a dispute in need of additional panel to resolve. The defense must be given an opportunity to present evidence to support the contention that an additional panel is not needed. And that's something that's just going to have to be litigated. And then also this Corias case, that's out there, the court found that there was a defendant. If there was a defendant that refuses in bad faith to agree to an additional panel, it could possibly be sanctionable. However, in that case, the board did not sanction the defendant, finding that it had denied liability for the claimed injury to the additional body part, for which additional panels were sought by the other side. So what happens when we have an initial evaluation by an AME? So this is not an additional panel. This would be a first panel because no panel had already been issued in that case. A party can still obtain a panel either by Labor Code Section 4060 if there had been a denial, and they can use that denial as the supporting document, or if there's an objection to a treating doctor's report either by 4061 or 4062. So most parties will seek an agreement first, but we have to know that that issue is out there, and that a lot of times if there is an AME that has been agreed to and has done the initial evaluation, the other side can obtain a first panel and additional specialty. So if there is an evaluation for subsequent injuries, let's say you have a situation where there is different injuries with different employers. That's no question that each of those employers can obtain their own QME. But what if the applicant is first evaluated by a QME for an injury and then has another injury that occurs after that initial evaluation? Well, the court has said that the applicant can obtain a new panel even if it's in the same specialty. There's a case called Navarro versus City of Montebello that says that there is no requirement that the applicant return to the initial evaluator for an evaluation of a subsequent injury claim. So it's very important that we know that is out there as well. All right, now we're going to shift gears here a little bit, and I'm going to kind of go through these next slides rather quickly, and you will have a copy of this, so a lot of these things you can just go back to for reference. Most people know by now that in April of 2021 there was a new fee schedule that was issued that obviously made things more expensive. It's never a new fee schedule that makes things less expensive. It's always more expensive. So the fees for assessing how much now a medical legal evaluation is going to cost. You're going to have a new base price for an AME or QME, and then once you identify the base price, then there's going to be a modifier which increases that. So the medical legal evaluations, reevaluations, and supplemental reports prices all went up. Also, missed appointment fees went up. The reviewing sub-rosa video footage, the cost of that went up. The testimony at a deposition went up. And then here you have all the modifiers. So as I mentioned in the beginning of the presentation, you can see here in the first bullet point, the agreed medical evaluator price increase went up by another 10%. So it was 25% more than a QME evaluation. Now it's 35%. And you're actually going to be getting a copy of this reference guide so that that you can have and just be able to look quickly to see what the increases were and what the base prices for some of these things are. So I am now going to turn it over to Leigh, who will be taking you through the rest. Leigh?
Okay, I'm going to begin with the word that I cannot say that well, attestation. Now, if you're sending any medical reports to a QME, you need to include this statement under the penalty of perjury, including the total page count and confirming that these documents were sent to the opposing counsel 20 days in advance. You need to make sure that that's included whenever you're sending that out to any QMEs. And what happens if it's not included? They will consider it not being received, and the QME is not required to review any of that information. I've included this practice tip, and my tip would be that if you're going through these records and you're performing one of these attestations of information you're going to receive, go through and pull out any of those unnecessary records. Get rid of those duplicates. Get rid of that 1,000 pages on the applicant's ingrown toenail when you're dealing with a back case. At $3 per page, we're talking about a fair amount of money that's going to be charged to have, a QME looking at records on an individual having a cold or issues that are not at all relevant to a workers' compensation orthopedic claim. So just make sure that when you're doing that as a practice tip, try to pull some of those out. You're going to have to make sure that you have an agreement from applicant's counsel, but it's easier if while you're getting the records and you're designating them, making sure you have an attorney who's going through and pulling out all of those unnecessary records, because the subpoena company is not going to do it for you. Their job is to get the entire record, send it over as a complete copy, certified from the location they're obtaining them from, and they're not going to go through and pull out all of those dupes, all of those unnecessary records. So can the QME cancel the evaluation if there's no attestation included? The answer is no. The one exception is if it is a psychological evaluation by a psychiatrist or psychologist that's specifically addressing compensability. Think of a Labor Code 4060 compensability evaluation in which you're relying heavily on records. If the psychiatrist or psychologist can't review it, they might be able to cancel, but it's not a basis that they can completely cancel the evaluation. So some things to look out for. I think the new fee schedule allows a lot more leeway with primary treating physicians billing as medical legal. It used to be much more, the fee schedule was much more specific about QMEs and what QMEs or AMEs could bill for. And now it just says medical legal evaluations and it goes by the type of specialty. We put this in here about records being sent by opposing counsel. I see a lot of attorneys who are saying, hey, this person's got all these prior claims. It's going to cost you, $10,000 for the QME just to review it. You should be settling this case. And I think it goes back to what we were talking about before, making sure you're getting rid of those duplicates, sending records that are relevant, because as you're going to see at $3 per page after the initial 200, we're talking about a lot of money that's going to be spent on for a QME to review some records. Another thing to look out for, this is actually the one thing that was included, I think, that is actually a benefit to defendants, and that is that QME actually has to answer your questions now. If you raise something in your cover letter that's not been addressed, the supplemental report isn't billable. They're not allowed to collect fees if a supplemental report is requested on an issue that was previously requested by the party. And if the QME refuses to write the report, you can request a referral to the administrative director. So I think this is a very important section, and it's a great thing that was added in, because now, the QMEs who, whenever you ask them to address, issues of, maybe applicants' prior injuries, and then you get a report that has no discussion of prior injuries and maybe even a denial of prior injuries, but you've included subpoenaed records with specific citation to particular pages that you want them to address, and they fail to do it, well, that's going to be an issue now, and something that the QME is going to have to address in the supplemental report. Another very important one that was added in some of these new fees is the missed appointments, the failure to go to QME evaluations. They have some new outlines if they don't attend, if they come in more than 30 minutes late, canceled within 6 days of the appointment, no interpreters available, the injured worker leaves before the exam is complete. A lot of these are then counted as a missed appointment under the new fee schedule. And I think, even a lot of the applicant attorneys are becoming aware of this, and they're actually sending letters to their clients saying, hey, if you miss this evaluation, you will be responsible for the fees. And so, if you get an individual who missed these appointments, my recommendation is you file that petition to compel and you file that petition for credit. And I think that that's a very important option to pursue, especially if you have somebody who's just simply unwilling to attend an evaluation, or an attorney who's trying to expand out the claim. Maybe they have an issue with the QME, maybe they don't like the orthopedic doctor when they wanted to get a chiropractor. So there's a lot more teeth now with these missed appointment fees. So the next section I included, I thought it was kind of a fun section to go through and add some deposition transcripts of doctors. I included a lot of these, a few examples in regards to billing. My goal is not to show that all QMEs or AMEs commit some type of fraud whenever they do billing. My goal is really to show is that when you get these reports in, you need to take a look at what some of these doctors are doing. And the goal really is to make sure that everything is up to snuff in terms of what these doctors are billing for. And so I included some Labor Code 4628 that says that basically no person other than the physician who signs the report can participate in the evaluation or summarizing of the records. And if the QME themselves does not perform the review of records, then they need to make additional inquiries. They need to review the actual documents. They need to ask questions about what was reviewed. And they cannot charge what was in excess of what was paid for the review, testing, clerical tests, or medical tests. Essentially, if they have somebody else doing the review, they have to bill for what was paid to that service. And then they must provide you an accounting for what was paid for those services to be rendered. So why is this information helpful? This allows you to challenge some of these doctor's reports, especially we were talking about earlier. You send in all these records, you get this report back, and the doctor says, oh, no prior injuries, causation, apportionment, there's nothing to be addressed because the applicant has no prior injuries. And you're like, well, I sent you 500 pages of a prior back injury, and this is a prior back claim, and you've mentioned it in your report, but for some reason you failed to miss the discussion. And usually to me, that's when I get the red flags that, this QME probably isn't reviewing their own records review or performing a substantive records review themselves. And so how do I do this? I usually take the doctor's deposition. I've been known to subpoena the doctor's file to request the actual information. And you might be asking yourself, well, why is this helpful? Well, if there's a violation of Labor Code 4628, the report is inadmissible and you're not liable for payment. You can file a petition to remove the QME and strike the reporting. And like we said before, if there's these ongoing violations, you can report the QME to the DWC. And this is not something I recommend on every case. Sometimes you tend to burn bridges when you do these things, but it's something in terms of cleaning out some of these bad QMEs in the system. You're also you're going to be left with either an assignment of a new QME, which might be a less favorable panel, or you might get the assignment of a regular physician, the old IME. So it's just something worthwhile considering. But then again, you can occasionally leverage it to get a good AME who might be more in your favor, which is what I've experienced at times whenever I've run into these issues. So what you want to do is, especially whenever you're looking at some of these issues with record reviews, not being substantial medical evidence, not reviewing prior injuries, you want to take this doctor's deposition. You want to ask them questions about how much time they spent with the individual. You want to ask them questions about who performed the records review, who performed the psychological testing, who performed the range of motion. I mean, these are major issues in terms of addressing a substantive report. And if the doctor themselves isn't performing it, and we have an office staff who's taking the history and basically determining what's relevant. We have an unknown records company performing a records review and maybe missing some major records. These are things that you're going to want to ask the doctor at a deposition. And like I mentioned before, whenever you get that bill in, take a look at the bill. If the doctor said, oh, well, there's an outside company that performed the records review, some doctors put that right in their medical report, but then they still bill for the entire time that they spent. Well, that's not proper. They can't bill for clerical staff time spent preparing certain medical histories, or if the clerical staff themselves maybe even perform range of motion testing, but the QME billed for it. So look out for some of these things. Look out for psych doctors who maybe take an MMPI-2, who do those Beck anxiety and depression scales, but really they have the applicant outside in the lobby performing the testing. Then they get it in and they actually send it out to an outside service to do the interpretation. But then all of a sudden you get a bill saying, they billed 4 hours for interpretation of MMPI-2 testing. Really, it's an online service that gives them the exact results. Most of these guys cut and paste it into their report. So be very critical about what's being billed. Look to make sure that what they're billing is proper. And if you're concerned about it, take that deposition. So here's a sample of actual billing that I had received from a QME. I mean, you probably look at it, you're like, hey, that's not that crazy. It seems like a relatively average, billing we might receive. I mean, 12.5 hours, relatively high. 3.25 hours for reviewing medical records, and 2 hours for history compilation. Now, normally you probably say, hey, well, that sounds about normal, maybe on the higher side, but I know this doctor, so I took his deposition. And when I took his deposition, I got some interesting answers. I said, so who performs the analysis of the records for you? And he straight told me, Mary runs the office and she's been with us. And she trained Becca and she trained Dominique, and the three of them have been helping me for many years. And so, so then I asked him, so did you review the records, or is this performed by that staff and you just review that? He said, well, the staff actually gave the material to us, so yeah. And then he confirms in the next question, so you have the staff do the review and then you just review that section of the document? And he says, yes. And I said, okay, well, did you take the history yourself? No. Well, who took the history? Oh, that's our most experienced person. That's Mary. And I asked him, well, is Mary a doctor? Is she a medically trained doctor? Oh, well, no, she just has experience. But the problem is is that this doctor billed for the record review, and then he billed 2 hours for the history. So that's, you know, almost 5.5 hours of services that he didn't perform. Now, Mary's not a doctor, but Mary's performing this entire evaluation. And I can tell you, when I got the report in, there were many missed issues. There were missed discussions of prior injuries. We had an individual who had, I think she had a prior back claim in the Army. She had frostbite on her feet, and we had a back injury with lower extremity issues. So, you know, what did I do with this? I was able to talk to the applicant attorney. We were, you know, I set it for a trial. We were able to get to an AME. We had originally a QME who found injuries to thoracic, lumbar, bilateral knees, bilateral feet, bilateral ankles, myofascial pain syndrome. And I was able to get it to an AME who looked at the records and said, well, yeah, this is extensively pre-existing, 80% non-industrial, and I only find her have injuries to the knees. So, you know, if you get some of these questionable doctors, and I think, you know, you probably know who they might be when you see them, you know, take a look at the billing, take a look at the stuff they're doing on their reporting, because, you know, these consistent missed issues are what is driving some of the cost increases on some of these cases. So here's another one that came in, and immediately I saw 24 hours. I mean, that's, you're working a full day, you know, for, you know, 24 hours nonstop work. And so when I looked at it, I see record review for 3 hours and 15 minutes, but medical research for 12 hours. Now that was odd. And so, you know, a total of 24 hours billed on a case. So I got the billing, and I took the deposition, and I asked, you know, who performs your record review? You know, she admitted this is done by Alexa. Okay. So what did you review? Is it just the pages from 12 to 16? Correct. And then I pointed out, well, you know, you billed 3 hours and 15 minutes. And so, you know, this doctor straight told me, you know, well, she performed 2 hours and 45 minutes of record review, and I only spent about 30 minutes doing it. So again, we have someone who's billing for a record review that they didn't complete, and they only completed 30 minutes of the record review. So then I continue, well, you're saying you spent 24 hours preparing this report, correct? And you said you spent 12 hours performing research, correct? And I asked her, you know, is this normal that you spend 24 hours in a report? And, you know, she kind of said, well, you know, not all of them, most of them, you know, take more than 6 hours. So, you know, now we have this testimony under oath. So, you know, I continued with her, you know, I pointed out, hey, we have in this case, you're reviewing medical reports for about 4 pages on this one. And, you know, and I told her my issue is that you're saying you spent 24 hours doing this. And so then, you know, she goes on to this discussion trying to justify, you know, it's 100 pages an hour, it's this thick, you know, I spent time face to face. And so, you know, that totals, you know, 24 hours. So, you know, I pointed out to her, you know, I don't know what the average day is, but, you know, I'm sure you typically work a 9 to 5, and that would indicate basically 3 consecutive days you worked on the report. And I asked her if that's accurate, and she said correct. And I said, but earlier, because earlier I'd established in the deposition that you said you performed 5 evaluations a week. So how did you spend 3 consecutive days? And that's when we get the backtrack. And that was the, you know, I don't do this every single time. They tell me that I can bill this way, so I'm doing what's allowed. And if it's different, you need to let me know. Well, really, we don't need to let you know, because really, you're supposed to know. You're the QME. And so this is another example of looking at the reporting saying, hey, 24 hours, that's not normal. Taking the doctor's deposition and getting them, you know, basically under oath and answering some questions about some of these questionable billing practices. And again, how did this help on this case? I had this QME and it was at 54%. And, you know, primarily because I don't think this QME actually spent the time to review the information. We had diagnoses and issues of information that was, you know, could have easily been parsed out to review the medical records. I eventually got it to a new QME, and I got 3% for a left shoulder issue. That takes a case, you know, from $85,000, and it results in a savings of $83,000 when we get down to the 3%. So, you know, that's a big savings, and a lot of that was simply because, you know, if you see something and it looks odd, it probably is. So another thing that I see come up a lot are these pain add-ons. You know, you might have, I see it a lot on meniscus injuries. You get a meniscus case in, you know, oh, I can't find anything wrong. I can't really even find a meniscus tear, but this person has pain. They're not rateable, so I'm going to give them 3% for impairment. Or in this case, so this is an exact example from a QME report, I'm going to give them 2% for the right foot. And so, you know, normally you might think, hey, that's just 2%. What is the big deal? Well, the big deal is when you start getting on these pain add-ons on conditions, you know, then you have impairment findings and you have future medical findings. And you take a case that has no value, and all of a sudden you create value, and all of a sudden you have this attorney who's arguing for, you know, maybe a $20,000 settlement on a case that arguably should be a 0% case and maybe shouldn't even have future medical care. And so I included the actual, this is right in the AMA guides, it's figure 18-1. And basically in box 1, it says that you first must find a conventional rating. So you must have first found something within the AMA guides that found a level of impairment. And basically what that means is you can't pass go, you can't collect the $200 until you find something rateable under the system. And then once that's done, then you can move on to adding the pain impairment. And the reason that QMEs so often use this is because it states right in there, you don't have to have an actual formal assessment. So you could just say, hey, this person has pain, look at their activities of daily living, and so we're going to add it on. But if you see those, make sure that they've actually found that pre-existing impairment and followed the requirements of figure 18-1 for the pain section of the AMA guides. So if you run into this, I included a case. This is Blackledge. You know, you could see exactly where this would come from. Applicant was a DRE category 1 with no impairment. They went to trial. The rater who had reviewed the case said this is a DRE category 1 and 0%. They can't even include the pain add-on. And the court basically said, you know, you can only add these pain add-ons to increase rateable impairment. And there can't be underlying whole person impairment with the pain add-on unless you first established it in the guides. And this is further mentioned in the rating for permanent disability. This is page 1-12. It basically says that you need to find whole person impairment rating under chapter 3 through 17 before you can include that pain add-on. So, you know, if you run into these, and I can tell you, I've had a number of cases go forward, you know, to trials, to MSCs, just on simple issues like this, because, you know, somebody's trying to add pain add-ons that are improper. And although it might not seem like a lot, if you're talking about, you know, maybe an 80-year-old individual who's doing a high-level occupation, those can start adding up quickly in terms of impairment. And it's impairment that should never have been added onto the case. Here's another issue that comes up a lot, a station and gait disorder. I have an example from a report. I had this doctor, you know, hey, this guy has a knee injury. If, you know, we take the meniscus tear with some chondromalacia, we're at 3%. However, he's got a station and gait disorder. That's 7% whole person impairment. So I'm going to rely on the 7% whole person impairment because it's higher. He even cites the AMA guides, page 529, saying, you know, when they're this, you know, when we have 2 ratings, we got to take the higher one. So, you know, hey, it seems right, but really it's not. When you understand that the requirements for a station and gait disorder. So some of these aren't only about, you know, making sure that you're not getting stuck with additional impairment, but also getting these doctors to stop making the same exact mistakes over and over again. And, you know, the difference between, you know, 3 and 7% may not be huge, but when you're talking about, you know, approaching, you know, possible life pension cases, when you're talking about, you know, maybe this is, again, an older individual, a higher occupational number, and then you're getting large swings in terms of permanent disability. I mean, it's double the permanent disability. It can make a big difference. And so when you're looking at station and gait disorders, page 529 requires that it has the full-time use of an assistive device. Now, what does that mean? That's a walker, a cane, crutches. And, you know, if they don't have that in the report, if they haven't mentioned that someone's using the full-time use of an assistive device, then that's not proper to use a station and gait disorder. So I actually took a cross-ex on this exact issue. You know, I went to the doctor. I said, you know, you relied on the station and gait table from page 529 in your report, correct? And, you know, his answer was whatever it says in my report. Okay, so I said, hey, on page 529, you're required to have the full-time use of a station and gait, and you're required to be dependent on assistive devices. And I asked him, you know, did you have that in your report where he indicated he required an assistive device? Well, no, he never indicated that And, no, there's nothing in our report discussing it. So I said, okay, so based on the fact that this individual wasn't using a full-time assisted device, do you believe it still should be applied in the case? And, he gave a pretty interesting response that if the Green Book says that he has to have full-time dependence on assisted device, and if he didn't, then, I have to follow what the Green Book says. I don't have a choice. I just do what I'm told. So, in an example in that case, it was a change of 13% down to 6% permanent disability. But I mean, that's a savings of $7,000. So you can see how, in that case, taking the deposition, it saved a fair amount of money to the client. And, also when you're talking about 6% versus 13% when you're negotiating these cases, it makes a big difference. Another topic that comes up a lot is the use of range of motion. I have some quick tips on this one. If you're using range of motion, it must be consistent among physicians. I actually just took a cross-examination 3 days ago on this exact issue, so I don't have a copy of it. Otherwise, I would have loved to put it in here. And what it says is that your measurements must be consistent within 10% between two trained observers. Now, why this is relevant is because if you have, let's say you have a PTP that finds this person's shoulder range of motion is 90 degrees flexion. You send them to a QME, and the QME has 180 degrees flexion. Well, that's a big difference. That's not within 10% of each other. And, I've seen it the flip side where we've had a PTP saying 180. We go to the QME and they're at 110. Well, explain the difference between those two. And if they're not within each other, then that range of motion cannot be relied upon. It basically is showing that we have inconsistencies of effort. And, they need to address why there's such an inconsistency. Is it the doctor performing the evaluation? Is it potential malingering by the applicant? But, doctor, can we really rely on range of motion if we have such variances in terms of the range of motion that's being performed? So keep these in mind if you get the range of motion testing in. Another really great one is measuring against the uninjured contralateral body part. So the AMA guide says that if you have an injured body part, you need to take the measurement of the uninjured body part. And why this is relevant is because there might be generally issues with people and their range of motion. Somebody moving their shoulder, they might consistently have restricted range of motion in their shoulders. They might have had a history of knee issues, and both their left and right knee have had a history of restricted motion, and then now they're claiming the right knee is injured, but their left knee has also decreased range of motion. So what you're supposed to do in that situation is then take the left knee, measure the uninjured body part, take the right knee, measure the injured body part, and the left knee will then become the baseline. So, I provide an example. Individual has a right shoulder injury with 120 degrees flexion. The uninjured left shoulder has 150 degrees flexion. That would then become the normal for what would be considered in terms of range of motion. That would decrease the range of motion from 180 degrees to be the normal down to 150 degrees. And why this is important is because if you run into that issue, the difference of whole person impairment between a normal of 180 degrees and a normal of 150 degrees is a large amount. So always make sure that if you run into some of these issues, that you're getting those different range of motion testing, that they're applying both the injured and uninjured body parts. So, we find this a lot too with the DRE versus the range of motion. The AMA guides straight up say right in there that the DRE is the preferred method. I can tell you I have cross-examinations all the time in which I have a DRE category 2 and have an applicant attorney who's trying to get the doctor to use the range of motion method, probably because it increases the level of impairment. So here's an example of when to use the range of motion of the DRE for the spine, because when you have multi-level involvement, that means multiple disc bulges in different areas. You have a prior surgery. You have reoccurrent radiculopathy due to a new injury. That means maybe they had prior injuries with radiculopathy, and now we have a new injury with radiculopathy. But in that case, you're probably going to have prior range of motion findings, which is going to help you in terms of comparing them. So when should range of motion not be used? When muscle spasm is present. And I can tell you, if you have a QME report, an AME report, and you have an individual with a back injury, they're probably going to be a noted muscle spasm is present. So look at that. Can't use it in that case. If there's inconsistent results, that's where we're looking for that 10% consistency. If we have the PTP who's at, 15 degrees flexion in the spine, and then the QMEs at 30 degrees, can we really rely on range of motion if we have vast differences between these two? Probably not. And if they're doing range of motion testing, make sure that they're doing it properly. Make sure that you have 3 consistent results. Ask them to look at the measurements they have. They should have noted three consistent results. They should have taken the 2 warm-up measurements. And that last one, it's almost funny because the use of an inclinometer, I mean, it seems like, oh, well, yeah, well, why wouldn't they use it? But I have taken, cross-examinations of chiropractors, and I said, well, can I see the devices you use to make the measurements? And they, oh, well, yeah, I just, I visually do it. Well, that's not compliant with the AMA guides. So look and see, or when you're taking the cross-examination, make sure they're compliant with the AMA requirements. And that's specifically on page 400, that use of inclinometers are the preferred device for accurate measurement. Some of them use little, like almost paper measuring tools. That's not the preferred method. That can create different results. So here's the DRE method. I think for this, the important part is, we spend most of our time litigating between DRE 2 and DRE 3. Look for that verified radiculopathy. Look for that EMG NCV. If it's not conducted, probably should be in a DRE 2. Look at the review of the MRI. Is there herniation? If there's herniation, you're probably going to be in the DRE 3. These are issues that are highly litigated. But when you get the report and especially look at the PTP report, see if they're supporting the basis for moving someone to a DRE 3, DRE 4. Make sure they're complying with the AMA requirements. Because I can tell you there's been a number of times I get that QME or AME report in, they're at a DRE 2. I get the PTP report in, and they're at a DRE 3 or DRE 4. And I'm looking at it saying, well, you haven't done any EMG NCV testing. You haven't shown that there's radiculopathy. You haven't shown that there's a dermatonal pattern, aka you haven't done the sensory evaluation. So make sure when you get these reports in that they're supporting their basis for moving them into the higher categories. So another issue that comes up a lot is the use of grip strength. You'll see these QMEs or PTPs saying, oh, well, this person has decreased grip strength, so we're going to add on an additional amount of impairment for this. Well, you can't use grip strength when there's decreased motion, painful conditions, deformities, or missing parts. And why that's important is because you'll often see, anybody who's got complaints of pain that's going to come up. So, look to see if they're meeting those requirements. It's an additional amount of impairment that can be relatively significant. Here's a great graph to keep, to look at whenever you get a report in that's got lower extremity injuries. Often doctors don't comply with these. If you have one of these diagnoses on one of these issues, go across, make sure they're not combining gait derangement with amputation, make sure they're not combining muscle strength, with atrophy. And it's an easy way to check off some of these. And I can tell you there's many doctors who still do not comply with these AMA guide requirements. And then my final one I want to point out, since we're running out of time here, is to challenge the PTP. If you get a PTP report in, set that doctor's deposition, send interrogatories, send the report to the QME, make sure that, you're not just going blindly in with a PTP report that's reviewed your QME, but you haven't had the QME address it. Look at the DRE categories, send interrogatories, and if you have that strong rebuttal to that PTP report, you're going to be much more successful at trial than you are, waiting until the trial and just showing up and saying, oh, well, that PTP report's ridiculous. Okay.
Well, gentlemen, I have to say it was a really great and informative presentation. And Leigh, I really enjoyed your true life studies, case studies, and the examples that you provided. It was interesting to see how photocopied a lot of those documents looked. They didn't look crisp like it was a fresh report. And I think that's probably a really good sign of that particular report needs to be investigated a little closer. I'd like to remind everybody that the MacroPro and Friends webinars are listed on the MacroPro website, so please be sure to look for those there. In addition to that, we do have one that's coming up November 30th on whose burden is it anyway. This is really important information. It's a great question to have answered, and it's going to have a new, fresh approach to that. On December 9th, we're going to have the healing power of humor. And our expert's going to talk about how we can implement that into the workers' compensation arena and our injured workers. So please make sure that you join us for that. And again, gentlemen, I want to thank you very much for joining us. Your presentation was extremely informative, and we'd like to wish all of you a happy Thanksgiving. Bye-bye now.
Thank you.
Thank you.
Thanks.